Good afternoon, everyone. Please do let me know if you can't hear me, but hopefully you can. First of all, I'd like to introduce myself. Thank you very much for coming along today. My name is Dawn Robertson, and I'm one of the partners in BTO's employment team. Can I please also mention, just as a sort of order of duty, that I need to do this. First of all, we're going to be recording today's webinar. And you will get access to that recording after if you would like to have a copy of that. If you've got any questions, can you please put them into the chat room, as it were. I'll be monitoring that, and at the end of the session, we should have some time to go through any questions that are raised there. Everybody will be muted for the period or the duration of the webinar, just so that we can get through everything we want to get through. My colleagues Douglas Strang and Pauline Hughes will be speaking today. Both Douglas and Pauline are members of our employment team and both have considerable experience of advising on employment law issues for both employers and employees. With Walkout Wednesday, so called yesterday, because up to 500,000 workers across the UK strike action against their employers, and the IMF recently declaring that the UK economy is going to shrink considerably this year and more than any other advanced economy. I think today's topic is quite apt, being employment law challenges for 2023. As such, today's session will begin with Pauline looking at the challenges facing employers in the coming months, the current state of the labour market, some updates on the law in relation to employment status, and then Douglas will take over and he'll look at the thorny subject of holiday pay, how one might dismiss an employee fairly, and some interesting discrimination cases that have cropped up over the last few months, and finally what to look out for in employment law terms in 2023. We'll have, as I said, a short period at the end of the webinar for some questions, so please do put some questions into the chat room if you have any. And without further ado, I'd like to hand over to Pauline. Thanks, Pauline.
Thank you, Dawn, for the introduction, and welcome to everybody for joining our session today. I'm going to be starting off by covering the impact of the current economic pressures on employers, and we'll talk about that in more detail, and the slide will follow up with me. I suppose, what are the current economic pressures on employers? Dawn has mentioned that there is current unrest amongst the labour market. Employers are facing a cost of living crisis with increased interest rates affecting building costs, rent, supplies and tools for employees to do their jobs. There's still the impact of Brexit, with employers who ship materials in and out from the EU facing import costs and further delays. And there's still the fallout of COVID and adapting to this new working world with hybrid working arrangements. And for employers struggling to deal with all that, there may be a knock-on impact on overheads. And one of the key overheads that employers will likely have is staff salaries. So what options do employers have to try and reduce staff salaries and effectively cut staff numbers? And the two options which I'm going to touch on today are redundancy and changing terms and conditions. So if we kick off with redundancy, there is a legal definition of redundancy in law. It's prescribed in law where there is a complete closure of a business. There can be a workplace closure where one of several sites closes or potentially relocates. But more commonly, it comes down to where there's a diminished requirement for employees to carry out work of a particular kind. And where employers are facing redundancy, the most important thing for them to clarify and be robust on at the outset is their business case for the proposed redundancy, identifying the why that they're in that situation. And then on from that, identifying who is at risk of potential redundancy. Are employers facing a single role redundancy? Is it one person? Or is it potentially more than that? Are we looking at a group of people known in the legal world as a pool of redundancy? And employers should give due consideration to whether there's any interchangeable skills or other people that may or may not be involved in a proposal. Numbers are important, and I've put on the slide 20 or more employees at risk. I'm not going to cover it in more full detail here, but it's just to flag that where employers are proposing to make more than 20 employees redundant within a 90-day period, that will trigger what's known as a collective consultation process, and there are enhanced obligations on employers in that type of process. So it's something to be mindful of, that once an employer has bottomed out their proposal and who is at risk, there is then a duty on them to meaningfully consult with employees. And what that really involves is discussing the proposal with employees, getting their feedback on the same, and opening up discussion to alternatives and ways to avoid any proposed redundancy. And there's also an onus on the employer to listen to employee feedback, and that's been fallen sharply into focus by that recent case listed on this slide, the case of Mogain, that was held in 2022, which was where a claimant was made redundant without due process being followed, and the Employment Appeal Tribunal found that she was unfairly dismissed, and in the judgment named that consultation should be genuine and meaningful, and a fair procedure requires that consultation takes place at a stage when an employee can still influence the outcome. So it's a reminder to employers that they should be listening to any feedback employees give in that type of process. Another option employers have to try and deal with economic pressures is to think about changing terms and conditions. And they may decide to do that in terms of reducing working hours, reducing pay, and they can try and think about it as a permanent change, or maybe even a temporary change to get through a particularly difficult period. And depending what changes are being proposed, if employers are proposing to materially change roles or materially change working patterns, that in itself could give rise to redundancy situation. So if an employer is in that situation, they should consider taking legal counsel before acting further. But I suppose, how can I change the conditions? I suppose one option, which isn't advisable, is if an employer unilaterally changes terms and conditions. Now, if an employer did that, at its base, it could give rise to employee unrest, grievances, but also at an extreme end, it could give rise to breach of contract claims. And for those who have more than 2 years service, unfair dismissal claims, potentially constructive unfair dismissal claims. So it's not advisable to just unilaterally change terms and conditions. And the approach is to again have a proposal as to why an employer is considering taking an action, consulting with employees about the same, and ultimately obtaining agreement to the same. And once that agreement has been obtained, it can either be covered off in a variation to contract letter signed by the employee, or an updated contract of employment can be issued. The other approach is known as fire and rehire, which has gained a lot of media attraction in recent times. And I'm now going to speak a little bit about what it means to fire and rehire employees on the next slide. And at its base, fire and are proposing to change terms and conditions and they cannot reach agreement with employees, they may decide to terminate contracts of employment and offer re-engagement on new terms and conditions. And this is an extremely risky approach to take. It could give rise to a whole host of employment law claims. And it's recently gained a lot of media attraction with the P&O Ferries case in March 2022, which attracted widespread media coverage where P&O effectively decided to immediately dismiss around 800 of their UK-based crew members by a pre-recorded Zoom message, offering them re-engagement on less favourable terms. And following that case, the government have actually issued a draft code in January 2023 on dismissal and re-engagement. And it's not but it will effectively set out, guidance on what the government advises employers do when they're in that situation. And effectively what it says is that employers can still use fire and rehire tactics, but it must only do so as a complete last resort. And if an employer failed to comply with that code, there could be an uplift of compensation to 25% in any tribunal claim. The code recommends that employers, for they meaningfully consult with workforces and unions before firing and rehiring. And if agreement cannot be reached, the employer should re-examine their business strategy in light of the potentially serious consequences, and also includes recommendations for sharing information. So there's now a duty on those employers to do that, and if they fail to do that, they could face an uplift in compensation at any tribunal. And I suppose leading on from the P&O Ferries decision, it's now kind of a prudent moment to talk about the current state of the labour market. We're seeing that it's now incredibly volatile, as Dawn mentioned, Walkout Wednesday yesterday. And I'm going to talk a little bit firstly about strike action, and I suppose it's becoming more and more increasing at its core. Strike action is where a body of employees refuse to work as a form of protest, and right now there's a lot of protest about pay, taking into account the current interest rates. We've seen it across various sectors in 2022, and it's following suit in 2023. In terms of the legalities around strike action, there were some updates in 2022 in respect of agency staff. Before 2022, there was a law in place that prevented an employment business from supplying an employer with temporary workers to perform the duties that strike workers imposed. And in 2022, with that piece of legislation listed on the slide, that has been overturned. So now employers can use temporary workers to cover the duties of strike workers when industrial action is ongoing. And there's also been media attention with the proposed anti-strike legislation listed on that slide, which effectively will allow the UK government to set minimum levels of service which must be met during strikes to ensure the safety of the public. And I believe that was actually passed in the House of Commons yesterday. So there's only the final stage of going through the House of Lords before that is actually rolled out into law. So a volatile market in terms of strike action, and I suppose what can employers do to reward staff? The obvious way is to increase their remuneration, but if that's not an option due to the economic pressures, another way employers can look at this is contractual benefits. Can they think about health schemes, life insurance schemes, potentially cars or car allowance? Can they give employers additional annual leave, or are there any additional non-monetary benefits they can consider? Additional days off for paid mental health days, cycle to work incentives, or even more flexibility in the workplace, maybe more working from home opportunities. These are all other things employers can consider to engage their staff and incentivise their staff to stay on. And talking of staff, I think now I want to turn to talking about challenges of employment status. This is a sort of hot topic in employment law, and it's only gaining more traction in the last year. Employment status really, whatever is documented in writing between a party and a contract, the starting point for any tribunal, if they're ever faced with a claim to determine employment status, is to look at the reality of what's happening between the employer and the person employed or engaged. And there is a spectrum of person in employment law. We have our employees who are given regular working patterns, who have to show up to do the work. There's mutuality of obligation, where the employees are expected to be given work and paid. So they're at one end of the spectrum. At the other end, there is a self-employed person who they hold complete control and flexibility as to how they perform services. They will have a number of clients they perform services to, and they will really dictate when any work is carried out and agree fees for that work. And right slap bang in the middle of those two categories, we have what's known as a worker, which has been the focus of a lot of media attention recently. And really you hear it as 0-hour workers or casual workers, and those are people who are offered work on an as required basis. They have an opportunity to reject work or to accept work, and it's really they're called upon to do work as and when is needed by the employer. And the Uber case gained a lot of media attention recently, where Uber drivers for the taxi-based business were arguing they were actually workers as opposed to self-employed people, which is what Uber coined them. And that case went through the courts in recent cases, and it was found by the Supreme Court that the drivers were workers, and that all that's really required to be a worker now is for a person to have personal service to the employer, i.e. they need to do the work themselves and can't give it to other people. And following Uber, there's been a whole host of case law. I've listed two here. It could be a whole seminar in itself if we focused on employment status. But just to highlight, how fact sensitive this topic is, I'm picking out two cases here. The first one is the case of Johnson, and in that case, the Employment Appeal Tribunal held that a taxi driver working through an app was not a worker, so sort of contrary to what the Uber judgment was, and that this person was a self-employed person because the claimant in that case could provide his services as infrequently or as often as he wanted. He could dictate the timing of those services and was not subject to the control of the employing entity. And it took into account the small proportion of work done through the app. So again, taxi driver in that case, but due to the flexibility of the arrangements, he was not a worker. The case of Waters listed on the slide, again, this was a claimant who ran a gardening business, and he had a contract with the Moat Cricket Club, which required him to work 40 hours a week during the summer months. And an employment judge found the claimant was not a worker or an employee in that case, and that he was a self-employed person, partly because his business had a turnover of 40k and the cricket club only accounted to 22k of that. So again, it just shows the difference in approach and how fact sensitive these issues are. And I suppose the challenges of employment status, if we move on to the final slide of my session of the talk, is that, it is the revenue. There can be tax implications for employers if they get this wrong and they're not taxing people who are really employees. There can be employment tribunal claims based on status. And if people who are being branded self-employed are actually employees, they could have potentially accumulated employment law rights during that time. But also holiday pay, which Douglas is going to speak about in more detail shortly. But the case of Smith against Pimlico Plumbers, effectively what that case decided was that if a worker has requested to take unpaid leave, there's no limit on the years for which that unpaid leave can be carried over. So, for example, if a worker was engaged for 10 years and took 4 weeks unpaid leave every year during that time, they could potentially claim for 4 weeks, 40 weeks paid leave, albeit they must have taken the leave that was unpaid to try and get that back. All that's required from a timing perspective is that the claim is raised within 3 months of the termination of employment or engagement. So that as well was a change in legislation and a consequence of getting it wrong. But holiday pay is something that my colleague Douglas is going to come on to now, as well as a number of issues for the remainder of the session.
Great, thanks, Pauline, and hopefully you can all hear me okay. I think I've turned the microphone back on. I think the issue of holiday pay and the issue of worker status, in a sense, go hand in hand, because I think, as Pauline highlighted, holiday pay is one of the real problem areas in relation to holiday status, as Pauline said. The definition of worker really is pretty wide now, and you don't need to establish a lot to show that legally you are a worker. If you have a contract to do work for somebody else, you don't have the right to appoint a substitute, and you're not in business on your own account, then you're going to be a worker. And I think there's probably a lot of companies and a lot of organisations out there who think they have self-employed contractors, consultants, etc., etc. The reality is they are workers, and they have all the rights that attach to workers, including the right to paid annual leave. And one of the real hot topics or problem cases of this year has been the case of Harper Trust against Brazil, which, again, I think there's probably a lot of employers out there not worried about this case, but possibly should be, because it does have very far-reaching implications in terms of how we work out holiday pay for both employees and workers. So what's the starting point? Well, we know that as a matter of law, all workers are entitled to 5.6 weeks annual leave, paid annual leave every year, and that is employees and all other workers as well. non-employed workers are entitled to 5.6 weeks paid annual leave a year. And the issue is really whether you're covered by a contract. If you're covered by a contract, you have contractual relations all year round, then your entitlement's 5.6 weeks. If you've got a contract for 6 months and then the contract ends, your entitlement's half of that, 2.8 weeks. So that's pretty straightforward, pretty easy. The regulations then tell us that for each week of annual leave, you're entitled to receive a week's pay. And the Employment Rights Act has got very detailed provisions about how you work out a week's pay in different scenarios. And it's really simple for for salaried staff or for those who've got fixed regular hours. Complications arise though for people that aren't working fixed regular hours, for example, people that work only part of the year. And that takes us to the Harper Trust case, where we have a claim by a Mrs. Brazel, who was a teacher. She had a contract throughout the year. She was a worker 12 months of the year, but she only worked term time. And she raised a claim that she wasn't getting enough holiday pay. Now, the employer accepted, as it had to, that she was due 5.6 weeks paid annual leave per year because she was a worker throughout the year. But the employer argued, when we work out a week's pay, she doesn't get the same pay she would get if she was working a week. It has to be reduced to reflect the fact that she doesn't work every week. Because if she was to get 5.6 weeks leave at her normal weekly pay, then she'd be getting proportionally more than our other staff who aren't term time. They need to work 46 weeks to get 5.6 weeks paid leave. She's only working at term time. She can't also get 5.6 weeks at her normal rate. So what the employer did here, they applied a percentage. They applied 12.07% to all hours worked and all earnings earned by the employee. That went into a pot, and that was then her holiday pay. So yes, she gets 5.6 weeks per year annual leave, but what she gets in terms of pay is worked out on this 12.07% basis. And that has for some time been a widely used approach. It was for a while expressly backed by ACAS in one of their guidance documents. Unfortunately, there's no legal basis for that at all. And in the Harper Trust case, it was rejected by the Supreme Court. And the court went back to the regulations and said, look, the regulations say you get 5.6 weeks holiday a year, and they tell us how to work out a week's pay. To work out a week's pay, what do? You look at the last 52 working weeks, excluding weeks where no pay was earned. So therefore, what you get for your 5.6 weeks annual leave in Mrs. Brazel's case is you get your normal week's pay. And that does mean that she gets proportionally more than her colleagues who weren't term time workers. But the Supreme Court says that's what the regulations say, and that's what we've got to do. And so this was dealing with a term time worker, but it applies equally to a casual worker who does work on some weeks, maybe does some weeks does a lot, some weeks does not very much work, some weeks doesn't do any. Very much an ad hoc pattern over the year. Plenty of employers use the 12.07% to calculate holiday entitlement, and there's simply no basis for that. You're entitled to 5.6 weeks a year, and each week you're entitled to a normal week's pay, working out the average, ignoring non-working weeks. Now, there's various solutions to that. Potentially, if you do have casual staff, simply issue them a new contract every time they do a bit of work, and the contract ends when they stop working. It's an administrative nightmare. It's really not practical, because we know now that all workers are entitled to a statement of terms and conditions on day one. So you need to do that every single time they start doing a wee period of work for you. So that's really not practical. Very, very complex issues and difficult to identify solutions, other than the fact that the government is now having a consultation, recognising the problems that this case causes, and basically consulting on giving legal backing to the 12.07% approach, so that holiday entitlement and holiday pay is proportionate to the amount of work actually done in the relevant year. And so you would average the remuneration out over a 52-week period, but you'd still include weeks where no work was done, and that would drag down the average. So consultation at the moment, we don't know what will happen. At the moment, Harper Trust applies and says you can't use 12.07%. If you are affected by the decision, you use casual staff, you have been using 12.07%. The consultation's still open, and I would encourage you to share your views with the government. The consultation runs until the 9th of March, but watch this space over 2023 in terms of how that is going to change. Another challenge, as ever, if you're going to dismiss staff, how do you do it fairly? There may be more dismissals given the current economic climate, but really just wanted to touch on a few cases from 2022, which maybe give us some food for thought for 2023. And the Abellio case deals with constructive dismissal. And there's been a few constructive dismissal decisions recently, and I just wonder if it's becoming slightly easier to claim constructive dismissal. We used to traditionally tell clients, you know, it's quite a high hurdle for an employee to get over to show that they've been treated badly enough to have been constructively dismissed, to be able to resign and claim unfair dismissal. But a few cases, as I say, recently maybe suggested it might be getting slightly easier. This case, I guess you can say it's the employer's own fault. What happened was the employee said he hadn't been paid sums due to him. He put in a grievance, then a grievance appeal, and the employer basically said, okay, you're right, we owe you £6,000 and we'll pay it by date X. Right? They then screwed up, didn't pay him by date X. They were a bit late in paying him, not out of any malice, just a mistake. And at that point, the employee resigned and claimed constructive dismissal. The tribunal said it wasn't constructive dismissal, but that was overturned by the Employment Appeal Tribunal because the ET hadn't properly engaged with the issue of last straw. This is this idea that, you know, you can resign as an employee in response to something that happens, which in itself isn't that big a deal. Certainly not material breach of contract, may not be a breach of contract at all, but it's something the employer's done that's blameworthy, and it can be a last straw. You resign not just because of that, but because of everything that's happened before, culminating in the last straw, everything taken together. That's the material breach of contract, and that's what entitles an employee to resign. So simply a reminder about the need to be careful and need to avoid even last straws. And I guess a very obvious practical lesson from that case, if you do, as part of a grievance outcome, reach a resolution, which is supposed to sort things out, don't then get it wrong in terms of implementing it and fail to do what you've agreed to do. The Marangakis case is a really important one. An employee was dismissed. She appealed against dismissal. And as part of that appeal process, she said, actually, I don't want my job back anymore because I've lost trust and confidence in my employer. I don't want my job back. But the appeal hearing went ahead and her appeal succeeded and she was reinstated. The employer said, well, you do have your job back. She then refused to come back to work because she didn't recognise the reinstatement. It wasn't what she wanted. And then later, in fact, she was sacked again for refusing to come back to work after being reinstated. So a bit of a mess. A claim arose, and the issue was, can she be reinstated against her will when she expressly said, I don't want reinstated? And the decision was pretty clear. If an appeal against dismissal is upheld, then the employee is reinstated with back pay, whether they want to or not. That's the inevitable consequence of an appeal against dismissal succeeding. To stop that happening, the employee would have had to formally withdraw her appeal, so she was no longer appealing, and she hadn't done that. And this rule would apply whether your disciplinary and appeal policies are contractual or indeed non-contractual. It's relevant, particularly, I think, for a number of our clients who've got rights of disciplinary appeal to an external body as a decision maker. It's pretty clear when that external body makes a decision to uphold the appeal against dismissal, the employee has their job back with back pay. It's not a question of whether the employer agrees with that decision or decides to implement the decision. It's a right of appeal. The appeal is upheld, the employee is reinstated. So really important, and even for employers that don't have an external appeal body, just be aware the inevitable consequence of upholding an appeal against dismissal is that this is now your employee again. Finally, on this slide on unfair dismissal, an interesting case which I was involved in, so I know a fair bit about, Scottish Federation of Housing Associations. What's the background here? Well, we know that in most cases, an employee needs to have 2 years service to be able to claim unfair dismissal, but there are some automatically unfair reasons for dismissal where you don't need any particular length of service, and the dismissal will be automatically or inevitably unfair. The employer cannot say this was a fair dismissal. So that's things like whistleblowing, health and safety actions, etc. But what's a little less known is that there's a further reason for dismissal. If the dismissal is said to be, or said to be political belief or affiliation, if you're dismissed for your political beliefs or affiliations or some reason connected with that, then there's no service requirement, but it's not automatically unfair. So that's an exception. It's really the only issue where you don't need 2 years service, but the employer can still argue it's a fair dismissal. And so in this case, the Employment Appeal Tribunal considered whether you can bring a claim for political belief dismissal if you were dismissed, in effect, for not being politically neutral in an organisation which requires neutrality. And the employee had said, and this was disputed and no evidence was actually ever heard on it, the employee said she was dismissed for wanting to stand in a general election for Scottish Labour. But she accepted it made no difference what party it was. It could have been any party. She would still have been dismissed because it was about not being politically neutral. And the Employment Appeal Tribunal said, no, you cannot claim political belief dismissal if your case is that your actual political beliefs had no bearing on the decision and it was a fact you weren't prepared to be neutral. So that's quite a limitation on that, the ability to claim unfair dismissal in circumstances where it relates to political neutrality. However, I'm going to come on to some cases about philosophical belief in a minute. The claimant had an alternative argument in this case, which succeeded in principle. It was a claim for discrimination on grounds of philosophical belief. The employee said, I have a philosophical belief that people who have the necessary skills should participate in a democratic process, and that might include standing for election. I say I was dismissed for wanting to stand for election, so I was discriminated against because of my philosophical beliefs. The only issue the EAT was considering really was whether belief in participative democracy could be a protected philosophical belief. And the Appeal Tribunal accepted the Employment Tribunal's finding that it was, that qualifies for protection under the protected characteristic of religion and philosophical belief. That's not the end of the matter, though. There was nothing in this decision that said an employer cannot have a political neutrality clause. It just means in some circumstances, if that is affecting people who believe in participative democracy, the employer might need to justify their actions, any actions they take in relation to that individual. But an interesting case for employers who may require political neutrality. Staying on the issue of philosophical belief, which I think is becoming the real difficult area in the whole field of discrimination and a real challenging issue, and something that I think is going to come up more and more as we go through 2023. As I said before, the Equality Act does protect religion and philosophical belief. Now, to be a protected belief, a belief needs to have certain features. It needs to be cogent and coherent. It needs to be concerned with a weighty aspect of life. It needs to be worthy of respect in a democratic society and not conflicting with the fundamental rights of others. Question arose in the 3 Miles case about veganism, ethical veganism, as it's sometimes termed, to distinguish it from merely following a plant-based diet. And in previous cases, certainly ethical veganism has been found to be a protected belief. A previous case where an employee was very much committed to an ethical vegan lifestyle, not using animal products, not traveling by bus because the bus might squash insects, etc., way beyond just a plant-based diet, and that was a protected belief. But the argument failed in this particular case, 3 Miles, because the employee had been dismissed by her employer after being arrested for suspected involvement in Animal Liberation Front burglaries. And she said her ethical vegan beliefs include a moral obligation to take action to relieve animal suffering, even if what she did was illegal. And the tribunal said, no, that cannot be a protected belief. A belief that the law should be broken in particular circumstances is not worthy of respect in a democratic society, which is one of the requirements for a belief to be protected. It also interfered with the property rights of other people. So that belief was not protected, and she couldn't claim discrimination. So that just highlights it's difficult to generalize and say veganism is or isn't protected. Any case about philosophical belief is going to be considered on a case-by-case basis, and employers certainly shouldn't be too ready to dismiss the possibility of a belief being protected by law. It's fair to say, of course, some claims are perhaps slightly optimistic in seeking to establish a philosophical belief, and you may have seen the case of McClung, where the claimant argued that his passionate support of Glasgow Rangers Football Club was akin to a religion and therefore a protected philosophical belief. It was a way of life, and he felt he'd been mistreated by his manager, who was a Celtic fan. A case obviously could only be brought in the west of Scotland. But the claim failed, and the tribunal said that's not a philosophical belief. Support is not the same as belief. It doesn't deal with a weighty and substantial aspect of human life. It's not something that's worthy of respect as a belief in a democratic society, and it doesn't have cohesion and cogency. What, in fact, is the Rangers' belief system was the question that the tribunal asked. But we see, people will seek to bring claims by arguing that they do have a protected philosophical belief, and some of them can be relatively inventive. Staying with this issue of philosophical beliefs, and I think it's probably fair to say one of the more contentious issues in society at the moment, gender reassignment and gender critical beliefs. And I'm not really going to talk about transgender rights or transgender status as such today. That probably does justify a webinar in its own right, but we're looking at clash of rights involving those who hold gender critical beliefs. And I think during the course of 2023, we're going to see more decisions, more cases, more appeal outcomes relating to gender critical belief. And by that, I mean people who believe that somebody's sex is fixed at birth and cannot change. And the question really is, does that opinion or belief amount to protected philosophical belief, protecting them from discrimination, or do those beliefs fail to respect the rights and dignity of others and therefore don't qualify for protection? And 2022's leading case was the case of Forstater, where the employment tribunal said to the claimant, no, your gender critical beliefs aren't protected because you've acknowledged to us that you would call somebody by their birth sex, you would misgender them, even if it violated their dignity. And since you've accepted that, your belief can't possibly be a protected belief. And that went to the Employment Appeal Tribunal, who disagreed with that. They said, look, if we're looking at the hurdle of whether beliefs are worthy of respect in a democratic society, beliefs are only going to fall foul of that if we're talking about something on the level of Nazism or totalitarianism. Said we recognise that people have freedom of expression, freedom of thought and conscience. And what that means is if we're talking about what beliefs do not qualify for respect, we need to set the bar really pretty high. It needs to be a fairly grave violation of human rights before we say that a belief system is not going to be protected. So in that case, the claimant's gender critical beliefs were protected, and therefore she was entitled to be protected from discrimination and harassment due to her beliefs. Critically, though, this doesn't entitle her or anybody else to deliberately misgender members of the trans community with impunity, because that would fall foul of the prohibition on harassment or discrimination against transgender persons. So what we're really seeing is that the holding of gender critical beliefs may be protected, but acting on them in particular ways may not be. And that, I think, is consistent with other cases we've seen in the past, potentially where Christian beliefs are protected, but that doesn't entitle someone to insist on evangelizing to colleagues or others when they've been expressly told not to. So it's a difference between the beliefs and the way those beliefs are manifested or acted on. And the Makareth case on that slide is a good example of that. A Christian doctor who had a religious beliefs, which meant he didn't accept that sex or gender could change, and that trying to do so, he said, was sinful, and society should not encourage people to, as he described it, impersonate another sex. So he insisted on misgendering patients and wouldn't use preferred pronouns. The debate with the employer about this, he eventually resigned and said he'd been discriminated against due to his religious beliefs. His claim failed, and that was upheld by the appeal tribunal because it was right to draw a line between his beliefs and the manifestation of his beliefs, and therefore he hadn't been unlawfully discriminated against. The employer was entitled to insist that he use a patient's preferred pronouns in order to respect the dignity of transgender persons. So it's just a good example of the difference between having beliefs and how beliefs are manifested. And as I say, I think this is going to be a repeat topic in 2023, and obviously in Scottish society at large at the moment, the issue of gender reassignment and gender critical beliefs is a contentious topic. Still on the subject of disability related challenges and other challenges, long COVID, we've kind of forgotten, I think, about the pandemic now. It's kind of history, but there are still people suffering long COVID, a good number of them. The Equality and Human Rights Commission says it might be a disability, it might not. You need to look at individual circumstances and consider whether it meets the usual definition of physical or mental impairment having a substantial long-term adverse effect on day-to-day activities. An example of a claimant who succeeded in showing that his long COVID was a disability was the case of Mr. Burke against Turning Point Scotland. The impact of his long COVID on him was enough to make it a disability. So just beware of that if you do have employees who have got issues with long COVID. Other ongoing COVID challenge, of course, working from home, the need, I think, to have a clear and consistent policy to avoid issues of favoritism and potential issues of discrimination as well. If someone who maybe does have a disability says, I need to work from home because I'm still concerned about working in the office and travelling on public transport, that may be something you need to consider. Very briefly, in conclusion, just a couple of other things to look out for in 2023, both fairly speculative. The potential abolition of EU law. The government has proposed a bill which says that any UK law which is derived from EU law will cease to have effect on the 31st of December this year unless it is put into UK law or it can be extended another 3 years. And so potentially we've got a bonfire of EU employment law rights, things including TUPE, working time regulations, protection for part-time and fixed-term workers and agency workers. They're all grounded in European law. So not a lot we can say at the moment because we don't know what the government will look to preserve in UK law, but keep an eye out for potential significant changes in UK employment law. And finally, we think this is going to happen. There is a bill in place which we expect to be passed, making changes to flexible working, employees seeking to be allowed to work flexibly. Important changes. A request can now be made from day one of employment. You can hire someone and then on day one, they put in a flexible working request. They'll now be able to make 2 requests in a 12-month period rather than 1. There's changes to how much information they need to give. Employers will now have 2 months instead of 3 months to deal with the request, and there needs to be consultation with the employee about the request. So definitely more onerous, likely to happen, and something that you definitely need to be aware of and think about. How is that going to impact on your practices? I think I'll hand back to Dawn now. We're just coming up to time, but if there's any questions in the chat, I think we may have time to take them. Dawn.
Thanks, Douglas. We don't have any questions at the moment. I had one thing that I just wanted to mention. Oh, I've just got one come in here, actually. So Vicky has said, while we await the outcome of the government consultation on holiday pay, are we okay to continue what we already do, or should we put changes in place to reflect the revised pay calculations until the government publishes the outcome? And I'm sure that this is a question that a lot of employers will be asking. So thanks for that question, Vicky. Douglas, do you want to see if you can answer that?
Yeah, I mean, the $1 million question, I guess, and I guess it's a tactical question rather than strictly speaking a legal question. At the moment, if you're applying 12.07%, you're not complying with the law because the Supreme Court said you can't do that. So you either change to be compliant with the law and then the government changes the law and you realise, well, actually, we might have to go back to what we did before, or you carry on doing something which is the wrong way to do it, and you risk the potential consequences from employees for that period. Because I would imagine if the law does change, it's not going to be retrospective. The law will say from effect from the following date, you can now use 12.07% method. If you haven't done that up to that point, then there is the run. I think it's worth doing an audit or an assessment in your organisation and thinking, how big a problem is this? I think in some organisations, if you worked it out the proper way or the 12.07% way, there's maybe not much difference. In other organisations where staff are very, very casual and there's big gaps where they're not doing any work but still covered by a contract, there may be a huge difference, and using 12.07% might be falling well short of what you should be doing. I think it's worth doing an audit and understanding what the issues are.
I completely agree, Douglas. I mean, that's what I was thinking. Effectively, if you work out how much you're paying at the moment under your existing arrangement and how much you might have had to pay under a different way for doing it, and then just see what the difference is and see what risk you're taking, and at least be consciously aware of what decision you're making about it. I think it's inevitable that the government is going to change it. They certainly didn't anticipate the decision that came out. So I think that that's probably a foregone conclusion, as you alluded to anyway. We don't have any other questions in the chat. The only other thing I just wanted to mention was just about employment status, and you were both talking about it, so happy for either of you to take this. But in terms of, obviously, Uber's kind of lowered the bar to some extent and effectively is saying if there's personal service, then you could be looking at worker status. But it was really just, what are the most common factors in your experience that seem to tip a business into having employed effectively employees or workers rather than having them on a self-employed basis, where they've unwittingly had them employed when they were intending to have them as independent contractors?
I think for me, what I always look for is the kind of regularity of work and the working pattern to see how often these people are being engaged or asked to work. Certainly self-employed people, it should be, they are really coming on to do a specific project, to provide particular services for something with a purpose, as opposed to being engaged or offered shifts on a kind of regular basis. And who is in control of how that work is done? Is the employer effectively saying, this is what we want you to do, and we want you to do it this way using our tools and equipment, or is the other person at the other end dictating that, and saying when it's on their terms, if you like, as to how the work's done? So those are the key things I would look for.
Douglas, did you want to add anything?
Yeah, I think the method of payment is quite important. If you're paying someone a fixed sum to do a job, and however long it takes, that's the fee for that job. If they do it quickly and efficiently, lucky them. If they take longer than they thought, that's a shame. As opposed to an hourly rate, that looks more like employment. And I think, yeah, if it looks like employment or worker status, I think it probably is in most cases. And I do think there's probably a lot of organisations out there who are just using the word contractor or consultant, and it really using that word is not going to help. As Pauline said, a court tribunal or HMRC are going to look at the reality of the relationship. Is that really employment or is it worker status? And unless someone is operating their own business, or unless they genuinely have the right of substitution, an unfettered right to send along someone else to do the work, you're hitting that worker box and all that follows with it: protection against discrimination, paid annual leave, limits on working time, etc., etc. And I think there are significant risks there.
Mm-hmm. Thank you very much. Yeah, I think we'll see what happens with the abolition of all the EU legislation. So the working time regulations may not be important after this, but we would still have national minimum wage and national living wage and that kind of thing. So there's still other things to consider. Can I just say thanks so much to both of you for what I consider to be a really, really helpful chat at a very, very timely time. It's all we've got time for today, so can I also thank everybody for joining us today. It's been a real pleasure to get to speak to you all, and it's lovely to see so many people joining us via the webinar. If you're not already signed up to get notifications about these types of events, then please do email our marketing team, marketing@bto.co.uk, and they'll get you put it onto our system so that you can find out about any events and potentially get any newsletters that we're issuing as well. Without anything more to say, and we're just after 1 o'clock, so hopefully you can all still get your lunch. Thank you so much for joining us today, and goodbye.
Thank you.
Thank you.